Hi, warriors. This is Jaylyn, my legal warrior. And today's segment is going to be about what cases can we actually bring to the San Diego Superior Courthouse. So, the court, as of April 10th, 2020, they specifically outlined a list of emergency matters that they are, in fact, going to handle. Now, I'm using the word handle because it doesn't mean that the court is now going to actually hear you speak in court, at least in the family law realm. And so the court instead is allowing the public to file emergency requests. So emergency requests is something that we could have filed by way of a restraining order, right? So if you've been abused, your life has been threatened in any way, then you can simply go down to the courthouse and obtain a restraining order. However, now the court has allowed us to file additional requests. So what are those emergency requests? Of course, it's going to be based off of each individual's situation, but the likelihood of you not wasting money hiring an attorney to try and change some sort of outcome that may have existed pre-COVID-19 or post-coronavirus, you should review the family code sections as to what is defined as an emergency, because those are considered ex parte, right? Those are ex parte issues, emergency issues. And the court, the California rules of court, the family code, the local rules, all of these different areas that you can look at and review help you define as to what is an emergency. So if there's going to be imminent harm or damage to a property, for example, yes, this is something that you can go and obtain an emergency order. If a child's being abducted, kidnapped, that is also something that you can obtain an emergency order for. If, for example, you are requesting child support, no, that is not an emergency basis, but it really depends how you articulate your request for this emergency. So if the other party just decided that they no longer want to give you child support, there's an existing child support order and they aren't abiding by it and you're relying on it in order for you to pay rent or your bills or whatever it might be, perhaps that might be an emergency issue. You're requesting the court to inform the other party, hey, these child support orders are still in effect and the other party should abide by it. So perhaps going to court and informing the court that the other party has stopped paying child support despite them still being employed and working and earning money, and you just want it to be noted on the record. I mean, this is sometimes a reason why people go to emergency hearings, is to note it on the record that I did take some sort of action during a time where I probably didn't need to take action, but I felt that it was an emergency, to put the court on notice that I'm not receiving child support despite me requesting the child support or spousal support, or any sort of obligations that stem from a judgment. I mean, another example is, let's say you're in the middle of selling your residence and the other parent is like, they're staying in the residence or they live in the residence during COVID-19 and they don't want to leave now because they don't want to be out and about, and the court order allows for you to evict them or to file a motion to remove them from the residence. I mean, this is a situation where the court should address it immediately, right? Because it is an emergency, especially if they're supposed to leave by a certain time. There's already a buyer on the line, and now what is it that we can do? So the parent that is living in the house or the spouse that's living in the house does not want to leave. So what is it that we're supposed to do when we have a court order in place and now COVID-19 is an issue, and this other parent or this other spouse can safely go to a different residence because this is something that they've been planning for a while, something along those lines? Those are probably an emergency to successfully have the sale of the residence go through, because who knows if you're going to get the same buyer again. So these are the sort of emergencies that you should be looking into. If you've now been served with a restraining order and you don't agree with the restraining order, so what is it that you can do now? Are you going to go and file an emergency request to object to the restraining order? No, don't do that. The court's not going to hear you out. The court's going to always err on the side of caution. And typically with these restraining orders, they do have a provision in there for supervised visitation. And if the court didn't include supervised visitation in its temporary orders, then it is certainly because with good reason. And if you wanted to argue with the court about that, by all means, if you want to try and see what happens, go ahead and do it. But if you're somebody who abused the child, or if you are the protected party and you protected your children and they were abused by the other parent, then don't fret, because the court is more likely than not going to deny the other person's request to modify the visitation schedule that was ordered under the restraining order. So those are just some examples that I wanted to lay out for you guys to kind of help you navigate through the emergency requests. I did want to share the screen from the San Diego Superior Court, and these are all the services that are going to be available. So they're still doing the chamber request, and chamber just basically means it's within the department or where the judge's office is. Just think of it as a judge's office. And so they'll still continue doing domestic violence, elder abuse, workplace violence and school violence, temporary restraining orders, and gun violence protective orders. But since we're focused on family law, the court is still going to be closed. However, they are going to reschedule family support matters. They're going to have the mediation matters be rescheduled. Clinics and workshops have been canceled. Temporary restraining orders that expired March 17 to April 30th, they'll be extended, and a new restraining order hearing will be set. And for all such cases, the court will be issuing orders, continuing existing orders, and assigning a new hearing date. And lastly, the court is going to allow for this right here. Ex parte requests for emergency family TROs and other emergency orders for all types of family matters. So where do we go for all types of family matters? We're going to look to the California Rules of Court. We're going to look to the local rules of court, and we're also going to look to the family code as to what is an emergency order. And you can simply Google that, or you can consult with an attorney to figure out what is exactly an emergency order. Right now, the way that they're doing the process is the person would still have to call to set up the emergency hearing by doing it before 10 a.m., the day before the emergency hearing is supposed to take place. You can file opposing papers by the next business day before 10 a.m. And then the court will go ahead and decide whether they'll grant the emergency or deny the emergency after hearing from both sides via writing. So there's no arguing in court, there's no phone calls, it's going to all be done through declarations. And then the court will email you the results, or if you go to the courthouse, you can wait outside and obtain the court order directly from the courthouse as well. From our understanding is they're not necessarily going to allow you into the courthouse. They are just going to accept paperwork from you or give paperwork to you, all right? So that's different than requesting and reviewing and deciding. Well, we hope that you can please share this with friends, family, your clique, whoever it is that you think might benefit from learning a little bit more about the emergency proceedings during COVID-19 and how the San Diego Superior Court is handling it for family law matters. Again, they're still hearing the domestic violence restraining orders and all restraining orders for that matter. And now they've allowed for true emergency requests. So look up those family codes, the California Rules of Court, as well as the local rules. Thank you, warriors.